Hello everyone, thank you for staying with us. If you're just joining us, it's a very good afternoon. And that breaking news, former Judge John Hlophe will remain barred from attending the Judicial Service Commission interviews after the Umkhonto weSizwe party lost its legal battle. The Gauteng High Court in Johannesburg delivered its judgment on the MK party's urgent application just a few moments ago. Ziyanda Ngcobo joins us in the studio to walk us through what's determined Judge Wilson to come up with that position, Ziyanda.
Well, in his 12-page judgment, Judge Stuart Wilson unpacked the various issues that we heard in court yesterday. So, for an example, there was a big debate about whether or not the full court's decision in the Western Cape High Court was an interlocutory application / interim order, and that wording being used interchangeably was also a subject of debate. And if it is an interim order, then as per Section 18(2) of the Superior Courts Act, you cannot actually appeal an interim order. Now, Judge Stuart Wilson finding that it is interlocutory in nature and therefore operationalizing, that order remains in place. In other words, the Judicial Services Commission was correct in its decision to say it will go ahead with its sitting as per that judgment that was handed down on the 27th of September. In fact, he says, the full court's order stands as a fact. And when it comes to this very issue, Hugo, in paragraph 9, Judge Stuart Wilson basically also goes on to say that he cannot say that the decision by the JSC was irrational. You heard Ngwako Mainesha yesterday arguing for the JSC. Basically, Judge Stuart Wilson agreeing with that full court that it's just a temporary restraint because of the fact that there's still Part B of that particular issue in the Western Cape High Court, which is dealing with whether or not it really was rational to even designate Dr. John Hlophe to the National Assembly. In fact, we've heard today that that matter has now been expedited and we're likely to hear the court's judgment on the 1st of November. Nevertheless, there was also the other issue of the validity of the other 5 designees. Now, you would have heard from Vuyani Ngalwana and Dali Mpofu, who were representing John Hlophe and the MK party respectively. They were basically saying that if the Western Cape High Court does eventually find that it was irrational to send John Hlophe to the JSC on behalf of the National Assembly, then the other 5 designees should be affected. Well, Judge Stuart Wilson also speaking about that, saying that the full court's decision does not taint the others in the first instance. The second thing that he mentions is that no one had actually asked the full court, being that of the Western Cape High Court, to consider the standing of the others. So in other words, this falls in line with the argument that was made by Freedom Under Law and the DA as well as the JSC, that in essence the other 5 designees have got nothing to do with this because they weren't even mentioned in the Western Cape High Court's order. So that's basically what happens. In terms of the costs, each of the parties are going to pay their own costs. There was a request by the MK party for a punitive costs order. They were arguing that, well, Judge Stuart Wilson, we actually tried to take reasonable steps to avoid reaching this point. And the judge basically saying that, there's no need for this. And there was also that issue about a press release by the MK party. You'll remember that Freedom Under Law had raised this, Max du Plessis in particular, and the content of this press release, about the political speak. And I think this also speaks to what former Justice Johan Krichler was speaking about, the courts trying to insulate themselves from a political battle. Nevertheless, Judge Stuart Wilson in paragraph 23 of his judgment also speaks about how the Constitution does protect free expression. So it's on these 3 pillars in the main, Hugo, that Judge Stuart Wilson has basically upheld the arguments made by the respondents, in particular the Judicial Services Commission, and that meeting will now go ahead on Monday after there was an attempt to interdict it.
Ziyanda, we must talk about what this means, what this really means for the operational autonomy of the JSC in conducting its duties despite ongoing legal controversies.
Well, not really. It doesn't affect them. And this is exactly the point that was made, because the Judicial Services Commission, and this is one of the arguments that they made, they don't assign people who are going to form part of it. They get names. Remember, there's 23 commissioners, 6 of which are sent from the National Assembly. Of those 6, 3 come from, the ruling bloc, and in this context, it's the Government of National Unity, and another 3 come from the opposition. Now, the JSC is saying, we're not a part of that process. If you ever had an issue, you could have gone back to the National Assembly and asked them to, for instance, perhaps try and replace Dr. John Hlophe. So in terms of how they operate, this was an exercise of basically insulating themselves, actually, Hugo, from a political process. And this has been the point that has been made consistently, that there's always this clash or, this mounting of arguments in the courts that are in essence political processes. And the courts have to, the judiciary in particular, has to avoid finding themselves in the middle of a political fight. And that's also one of the reasons that the JSC pretty much gave to say there's an order by the Western Cape High Court that was delivered on the 27th of September. In that judgment, they had considered the consequences of Dr. Hlophe's absence, which means they would have also considered constitutional implications as well. And according to that order, it is an interlocutory application or an interim order in essence, so it doesn't have the effects of a final order.
Well, therein lies my next question, right, which speaks to the distinction, right, and how it affects the timeline and strategy for any potential appeals, because we're all too familiar with how the MK party has operated in the past, right? That when a judgment is handed down, almost immediately there is an appeal of sorts.
But this is an urgent court, and this is, I think, a point we also need to emphasize. If you're filing an urgent interdict, it goes to an urgent court. And in this judgment in particular, I think what it would have assisted Judge Stuart Wilson is that he actually has a decision that was made in the Western Cape High Court by a full bench. And in that aspect, you will see a lot in his judgment relying on that. And that's exactly what the JSC also relied on. What we understand at this hour, Hugo, is that the MK party will be meeting with its lawyers in the next hour or so to deliberate on this. But as it stands, at least from the JSC perspective, they can go ahead. Remembering as well, Hugo, that part of the consideration made by the Western Cape High Court is a concept called the balance of convenience, which would look at who would be most inconvenienced with the postponement of the JSC. Now, there are cost implications, for an example, when there are JSC sittings. Hotels and transport are booked for these commissioners, but also if you take the risk of continuing with the JSC sittings with Dr. Hlophe there, having not finalized Part B of the application, which is looking at his designation in totality, what happens then when the court actually finds that it's irrational for him to be a member of the JSC and the decisions that were taken at that JSC sitting? Do you go back to those judges and say, well, now your appointments are irrational and unlawful? So they weighed those options up, and in terms of the risk, as we heard from the DA's Michael Bishop, the risk is much higher of by having Dr. John Hlophe there than him not being there at all.
I'm going to take you back for our final question to Judge Johan Krichler, where he says that cases like these put judges in positions where they have to take decisions that are politically loaded. What do you read into that statement, or what was he actually saying?
Well, in essence, I think this case, what it has brought to the fore, and the main question here, and we also heard, Judge Stuart Wilson also pondering about the same thing, is can a court intervene in a decision that was made during a political process, and in this aspect, Parliament, because it's the National Assembly that actually made the decision on who to designate to the JSC. That's as per the Constitution. Now, there isn't strict requirements at this point in time, there's only a parliamentary convention, but there isn't anything in the Constitution itself that says this is the criteria that you have to follow when you designate a member of the National Assembly to the JSC. And in fact, this is part of the argument that was made by the MK party that if you're going to have a problem then with Dr. John Hlophe being a part of the JSC, then you should have even had a problem with him being sworn in as a member of the National Assembly. Because if he qualifies to be a member of the National Assembly, the only criteria there is right now is to say as long as the official or the political party nominates them, and then the name goes through. Now, for the first time this year, the National Assembly didn't just go ahead with the parliamentary convention where a name is given by each political party and then they sent to the JSC. They actually had a full-on debate on who should be sent to the JSC because of what we've also seen previously taking place at JSC interviews where there were lots of questions around, politics also muddying the waters of what is meant to be, a balance between a judicial and a political process. Now, this goes back to your question then, and this is what I think Justice Jan Krichler was touching on, to say this is now murky waters because of our fundamental principle of a separation of powers in particular. So now if you have the courts pronouncing on a political process, it becomes very, very difficult and it becomes very, very muddied. And that's why in Part B, the request has been made to the National Assembly by the DA, Freedom Under Law and Corruption, that they need to do more, and in terms of the vetting process of the people who go to the JSC, and not just merely rubber stamp decisions. What that more is what we're expecting to hear from the Western Cape High Court when they deliver their judgment on Part B of that application.
Ziyanda Ngcobo, always great to have you on the show and in conversation.
Thanks, Hugo.
Unpacking for us that issue as the JSC session is set to start on Monday.